गुड मॉर्निंग। चलिए आज हम लोग स्टार्ट करेंगे पॉलिटी, इंडियन पॉलिटी स्टार्ट करेंगे। पहला चैप्टर है कॉन्स्टिट्यूशनल फ्रेमवर्क, कैसे हमारा संविधान बना 1773 से और 1858 तक, कैसे हमारे संविधान को बनने में समय लगा, इसके बारे में समझेंगे। सबसे पहले ब्रिटिशर्स इंडिया और उन्हें कंपनी रूल, जो कंपनी के फॉर्म में आए थे, इसलिए उन्होंने कंपनी के रूप में भारत को रेगुलेट किया। और जो ब्रिटिश गवर्नमेंट थी उसने कंपनी को अपने हाथों से रेगुलेट किया। उसके लिए उसने कुछ रूल्स रेगुलेशंस लाई। जैसे पहला जो रेगुलेशन लाई वो रेगुलेटिंग एक्ट ऑफ 1773 पहला एक्ट आया। दूसरा आया पिट्स इंडिया एक्ट ऑफ 1784 और तीसरा आया चार्टर एक्ट ऑफ 1833 और चौथा आया चार्टर एक्ट ऑफ 1853। सबसे पहले क्या हुआ कि रेगुलेटिंग एक्ट ऑफ 1773 में कंपनी जो थी वो पूरी तरीके से ब्रिटिश अंडर आ गई और उस ब्रिटिश गवर्नमेंट, ब्रिटिश पार्लियामेंट के अनुसार दिए गए जो एक्ट्स थे उनके अनुसार उसने चला। रेगुलेटिंग एक्ट में बताया गया कि कंपनी जो है उसमें 3 कोर्ट होंगे। एक कोर्ट बंगाल में होगा, एक कलकत्ता में होगा, एक मद्रास में होगा। और ये तीनों कोर्ट जो हैं ये चालू हुए। उसके बाद यहाँ पे एक बोर्ड ऑफ डायरेक्टर बनाया गया। बोर्ड ऑफ डायरेक्टर्स जो थे वो पूरा जो एडमिनिस्ट्रेशन, पॉलिटिकल सिस्टम, मिलिट्री तीनों ही देखा करते थे। और यहाँ पे एक सुप्रीम कोर्ट बंगाल में बनाएगी जो इसकी देख रेख के लिए बनाएगी। और इस तरीके से ये 1773 में चालू हुआ। इस समय जो लॉर्ड थे, लॉर्ड वॉरेन हेस्टिंग को थे, इसलिए ये इस समय जो लॉर्ड हेस्टिंग थे उन्हीं के अनुसार 1773 के अनुसार ही बनाया गया। पिट्स इंडिया एक्ट जो था वो 10 साल, पिट्स जो थे वो पीएम थे ब्रिटिश पार्लियामेंट के। पिट्स इंडिया एक्ट लगभग 11 साल बाद आया 1784 में, और यह देखने के लिए कि कंपनी कैसे रेगुलेट कर रही है। 1784 में इसमें एक नया क्लू जोड़ा गया जिसे कहा गया कोर्ट ऑफ डायरेक्टर। अब इसमें कोर्ट ऑफ डायरेक्टर होंगे जो फाइनेंशियल, जो कॉमर्स को देखेंगे अलग, कॉमर्स को अलग देखेंगे, पॉलिटिकल और मिलिट्री का एडमिशन करने बोर्ड ऑफ डायरेक्टर्स रहेंगे। इस तरीके से धीमे धीमे 1784 तक इसे रेगुलेट किया वॉरेन हेस्टिंग ने। उसके बाद 1784 के बाद हमारे लॉर्ड कॉर्नवालिस आ जाते हैं और वो रूल करते हैं। तो उसके बाद क्या हुआ कि रेगुलेटिंग एक्ट के बाद 1773 के बाद पिट्स इंडिया एक्ट 1784 आया। और उसके बाद चार्टर एक्ट 1833। चार्टर एक्ट 1833 में लगभग बड़े काम किए गए। इस 18 चार्टर एक्ट 1813 भी आया, लेकिन चार्टर एक्ट 1813 में ज़्यादा जो मोनोपोली थी सिर्फ चाय में रह गई थी और सारी मोनोपोली कंपनी से छीन ली गई। इस तरीके से चार्टर एक्ट 1833 आया जिसमें सेंट्रलाइज्ड, पूरा सेंट्रलाइजेशन कर दिया गया। और इसमें गवर्नर जनरल जो थे उनको गवर्नर जनरल ऑफ बंगाल कहा जाता था, उन्हें गवर्नर जनरल ऑफ इंडिया कहा जाता है। लॉर्ड विलियम बेंटिक पहले गवर्नर जनरल ऑफ इंडिया बने। उसमें पूरा सेंट्रलाइजेशन किया जा सका था, लगभग पूरा सेंट्रलाइजेशन उनके हाथ में आ गया था। इस तरीके से हम देखेंगे 1833 के बाद 1853 आया। 1853 के समय लॉर्ड डलहौजी था। लॉर्ड डलहौजी जो था उसने डॉक्ट्रिन ऑफ लेप्सी के द्वारा और मिस रूल के अगेंस्ट बहुत सारी जो रियासतें थी, प्रिंसली स्टेट थे, उसको अपने कब्जे में ले लिया। तो इस तरीके से 1853 तक आते आते लगभग सेंट्रलाइजेशन जो था वो सेंट्रलाइज्ड हो चुकी थी और इसमें कुछ सुधार आए। कहा गया अब जो कंपनी है उसको बहुत दिनों तक रूल, कभी भी उसको डिसबैंड किया जा सकता है। इसके बाद जो हमारा 1873 से लेकर 1858 तक ये रूल चला। उसके बाद यहाँ पे कंपनी रूल आता है। कंपनी रूल क्योंकि 1857 की क्रांति ने बहुत ज़्यादा ब्रिटिश पार्लियामेंट को झकझोर दिया, इसलिए अब जो कंपनी रूल था उसे बंद करके क्राउन रूल कहा गया कि अब जो है वो कंपनी रूल बंद होगा और ये डायरेक्ट ब्रिटिश पार्लियामेंट के अंडर रूल करेगा। इसमें बताया गया कि 1857 के बाद जो 1857 के टाइम लॉर्ड कैनिंग थे और लॉर्ड कैनिंग को ही वाइसरॉय बना के भेजा गया भारत। तो लॉर्ड कैनिंग जो थे भारत के प्रथम वाइसरॉय बने और 1858 से लेके 1947 तक 1947 तक उन्होंने लॉर्ड माउंटेन ने रूल करा। और लास्ट जो गवर्नर जनरल ऑफ इंडिया थे वो सी राजा गोपालचारी को बनाया गया। पहले माउंटबेटन बने, उसके बाद सी राजा गोपालचारी। तो इस समय पहला जो रेगुलेटिंग क्राउन रूल के अंदर जो पहला गवर्नमेंट ऑफ इंडिया, अब जो रेगुलेटिंग एक्ट कहा जाता था उसे गवर्नमेंट ऑफ इंडिया एक्ट कहा गया। तो गवर्नमेंट ऑफ इंडिया एक्ट 1858 पहले आया। इसमें बताया गया कि अब एक क्या होगा, एक ब्रिटिश पार्लियामेंट रूल करेगी और ब्रिटिश पार्लियामेंट के अंदर एक सेक्रेटरी ऑफ स्टेट होगा जो डायरेक्ट वायसरॉय को रेगुलेट करेगी। वायसरॉय को एक एग्जीक्यूटिव काउंसिल बना के दी गई जिन्हें कुछ पावर्स दी गई और कुछ लेजिस्लेचर बनाने का पावर दिया गया। और कहा गया कि अब जो है ब्रिटिश जो है वो डायरेक्ट रूल करेगी और जितनी भी रियासतें पहले हड़पी गई उनको भी छोड़ दिया जाएगा। इस तरीके से गवर्नमेंट ऑफ इंडिया एक्ट 1858 आया। उसके बाद इंडियन काउंसिल एक्ट ऑफ 1861। इंडियन काउंसिल अब क्या हुआ, अब तीन काउंसिल एक्ट आए। इंडियन काउंसिल एक्ट ऑफ 1861, 1892, 1900 फिर 1909, ये 3 रेगुलेटिंग काउंसिल एक्ट आते हैं। काउंसिल ऑफ इंडियन काउंसिल एक्ट मतलब जो थोड़ा बहुत सुधार किया गया उसे ही कहते हैं काउंसिल एक्ट कहते हैं। तो पहला गवर्नमेंट ऑफ इंडिया एक्ट 1858, फिर इंडियन काउंसिल एक्ट। इंडियन काउंसिल एक्ट 1861 में लॉर्ड कॉर्नवेल्स ही थे, थोड़ा थोड़ा अधिकार देना चालू करते हैं, रिप्रेजेंटेशन चालू करते हैं धीमे धीमे काउंसिल में। इंडियन काउंसिल एक्ट ऑफ 1892, इंडियन काउंसिल एक्ट ऑफ 1892। इंडियन काउंसिल एक्ट जो 1892 था उसमें थोड़ा लेजिस्लेचर लॉ बनाने के लिए कुछ चुनाव देने की उनकी फरमाइश की गई और धीमे धीमे बजट पोर्टफोलियो भी आना, ऑर्डिनेंस लाने की जो शक्ति थी, जो पोर्टफोलियो था, जो बजट था, धीमे धीमे इन पे काम चालू हुआ। और रेगुलेटिंग इंडियन काउंसिल एक्ट ऑफ 1909, इंडियन काउंसिल एक्ट 1909 में थोड़ा सा उनको सेपरेट इलेक्टोरेट, मॉर्ले मिंटो रिफॉर्म जिसे कहते हैं, मॉर्ले मिंटो रिफॉर्म जिन्हें कहते हैं, उसमें थोड़ा सा ढील दी गई और सेपरेट इलेक्टोरेट जिसमें मुस्लिम खड़ा होगा, मुस्लिम ही लोग उसको इलेक्शन करेंगे, सेपरेट इलेक्टोरेट की यहाँ से स्टार्टिंग होती है। फिर गवर्नमेंट ऑफ इंडिया एक्ट आपके ऑफ 1909 के लॉर्ड कर्जन 1905 में आया था, उसने विभाजन की बात करी। और इसके बाद लॉर्ड कर्जन के बाद लॉर्ड मिंटो आ गए और मिंटो जो थे उन्होंने 1909 में लॉर्ड मिंटो मॉर्ले मिंटो रिफॉर्म्स कहा गया। फिर क्या हुआ कि 1940 में विश्व युद्ध स्टार्ट हो गया और 1918 तक ये प्रथम विश्व युद्ध चला। उसके बाद 1919 में गवर्नमेंट ऑफ इंडिया एक्ट एक आया और गवर्नमेंट ऑफ इंडिया एक्ट में 19 में बहुत सारे सुधार ला के रखे गए। यहाँ पे क्या हुआ कि पहले अब थोड़ा और भी सेपरेट इलेक्टोरेट अलग अलग लोगों के लिए भी लाए गए। उसके बाद यहाँ बताया गया कि 1909 में यहाँ पे डायरकी लाई गई। डायरकी जो थी यहाँ पे लाई गई 1919 में डायरकी लाई गई और कहा गया कि यहाँ पे 2 कैटेगरी होंगी, एक रिजर्व कैटेगरी होगी और एक ट्रांसफरेबल होगी। रिजर्व जो होगी वाइसरॉय के हैंड में रहेगी और जो ट्रांसफरेबल होगी उसमें इंडियन जो हैं वो कर सकते हैं। यहाँ पे बजट में क्वेश्चन पूछने डिस्कशन की परमिशन दी गई लेकिन काउंटर क्वेश्चन करने की परमिशन नहीं दी गई। इस तरीके से 1919 में रॉलेट एक्ट और इस तरीके से 1990 एक्ट बना। लेकिन इसी 1999 एक्ट को सर्वे करने के लिए कैसा है, इसलिए साइमन कमीशन बनाया गया। साइमन कमीशन जो था वो 1999 के 10 साल पूरे रहने के 1929 में आना था, लेकिन 2 साल पहले 1927 में भारत आया। इस साइमन कमीशन में लगभग सारे ब्लैक में से कोई भी नहीं था, सारे वाइट पर्सन थे, इसलिए इसका बहिष्कार किया गया। और लगभग इंडिया में हर जगह, चाहे मद्रास हो, चाहे लाहौर हो, पंजाब, कराची, हर जगह। लाहौर में क्या हुआ, लाहौर में जब ये पहुंचा तो वहाँ पे साइमन कमीशन गो बैक के साथ लाला लाजपत ने नारे लगाए जिन पे लाठी चार्ज हुई। उन्होंने कहा कि ये मेरे सर पे पड़ने वाली लाठियाँ जो हैं ये ब्रिटिश साम्राज्य के लिए ताबूत में आखिरी चीज़ साबित होंगी। इस तरीके से साइमन कमीशन जो था पूरी तरीके से बहिष्कार कर दिया गया। उसके बाद कम्युनल अवार्ड्स, राउंड टेबल कॉन्फ्रेंस 30 में 1931 में हुआ, लेकिन इसमें किसी में भी इंडियन नेशनल कांग्रेस ने पहले और तीसरे में नहीं की। दूसरे में गांधी और इरविन के बीच में पैक्ट होता है कि अब वो जाएंगे और राउंड टेबल कॉन्फ्रेंस को क्या कहते हैं अटेंड करेंगे। इस तरीके से वहाँ पे उसके बाद कॉमनल अवार्ड मैकडोनल्ड जो थे, मैकडोनल्ड सरकार आई और उन्होंने एक कम्युनल अवार्ड घोषित किया जिसमें डिप्रेस क्लास के लोगों को, वुमेन्स को, एंग्लो इंडियंस को और सबको राइट दिए गए। तो गवर्नमेंट ऑफ इंडिया एक्ट, उसी के बाद हमारा नया एक्ट आता है जिसे कहते हैं गवर्नमेंट ऑफ इंडिया एक्ट 1935। गवर्नमेंट ऑफ इंडिया एक्ट 1935 आता है और उसमें कहा गया कि अब क्या होगा कि यहाँ पे इलेक्शन होंगे, इलेक्शन के साथ साथ यहाँ पे बजट भी होगा और प्रोविंशनल यहाँ पे फेडरल पब्लिक सर्विस कमीशन और सेंट्रल स्टेट पब्लिक सर्विस कमीशन, जॉइंट पब्लिक सर्विस कमीशन और बहुत सारी चीज़ें लाई गई। और यहाँ पे वाइसराय की जो लेजिस्लेटिव असेंबली थी उसमें मेंबर्स भी बढ़ा दिए गए, काफ़ी कर दिए, 64 तक कर दिए गए। और वाइसराय की लेजिस्लेटिव एग्जीक्यूटिव काउंसिल थी उसमें भी संख्याएं बढ़ा दी गई। इस तरीके से देखते हैं कि गवर्नमेंट ऑफ इंडिया एक्ट जो था 1935 का वो काफ़ी अच्छा साबित हुआ। और इसके बाद लगभग 36 थे हमारे इलेक्शन चालू हो जाते हैं प्रोविंशियल लेवल पे। इस तरीके से लास्ट और जो कि इंडियन इंडिपेंडेंस एक्ट 1947 आया। इसमें बताया गया कि अब क्या होगा कि इंडिया और पाकिस्तान दो अलग अलग डोमिनियन स्टेट कंट्री होंगे और प्रिंसली स्टेट चाहे सेपरेट रह सकते हैं या फिर इंडिया पाकिस्तान को किसी को भी ज्वाइन कर सकते हैं। इसके बाद आता है कि जब हमारी इंडिया आज़ाद हो गई तो उसमें क्या हुआ कि हमने सोचा कि अब हम अपना कॉन्स्टिट्यूशन बनाएंगे। कॉन्स्टिट्यूशन बनाने की जो कयावत थी वो 1934 में एम.एन. रॉय के द्वारा, 1935 में इंडियन नेशनल कांग्रेस के द्वारा, 1935 में इंडियन नेशनल कांग्रेस के द्वारा और उसके बाद 1946 में कैबिनेट मिशन के द्वारा 46 में और 1947 में हमने अपना संविधान बनाने की शुरुआत की। लगभग 9 दिसंबर को पंडित नेहरू रेजोल्यूशन लाते हैं, 13 पहली मीटिंग होती है और उसके बाद 11 तारीख को डिस्कशन होता है और 13 को इस तरीके से स्टार्टिंग होती है। तो जो मेकिंग ऑफ इंडियन कॉन्स्टिट्यूशन थी, डिमांड फॉर कॉन्स्टिट्यूशन असेंबली, जो डिमांड फॉर कॉन्स्टिट्यूशन असेंबली की डिमांड कब से की गई, मैंने आपको बताया कि 1934 से लेके और 1946 तक कैसे 46 तक चली। कंपोजिशन ऑफ कॉन्स्टिट्यूशन असेंबली, और जो कॉम्पोजिशन थी, जो कॉन्स्टिट्यूशन असेंबली बननी थी जिसमें लगभग 299 सीटें थी, जिसमें मुस्लिम लीग उसे नहीं मिली थी, तब उसकी कुल सीटें जो थी 300 के ऊपर थी, लेकिन मुस्लिम लीग ने अटेंड नहीं किया और इस तरीके से मुस्लिम लीग के जो जिन्ना और गांधी दो लोग जो थे कॉन्स्टिट्यूशन असेंबली नहीं थे और कंपोजिशन ऑफ कॉन्स्टिट्यूशनल असेंबली जो बनी। उसके बाद वर्किंग ऑफ कॉन्स्टिट्यूशनल असेंबली, अब क्या हुआ कि वर्किंग उसकी जो कॉन्स्टिट्यूशन असेंबली थी, उस जो संसद थी, पार्लियामेंट थी, उसमें ही कॉन्स्टिट्यूशन असेंबली बनाई गई और उसमें लेजिस्लेचर का भी काम करेगी और बाकी जो समय था उसमें कॉन्स्टिट्यूशन बनाने का भी काम चलता रहा। तो वर्किंग ऑफ द कॉन्स्टिट्यूशन में सबसे ऑब्जेक्टिव रेजोल्यूशन जवाहरलाल नेहरू ने 9 दिसंबर को सबसे पहले ऑब्जेक्टिव है रेजोल्यूशंस लाए, जिसमें उन्होंने बताया कि हमारा कंट्री कैसा रहेगा, फेडरल रहेगा, फ्रीडम मिलेगी, फंडामेंटल राइट्स रहेंगे और इस तरीके से उन्होंने ब्रीफ एक कह सकते हैं कि जो हमारा संविधान था, प्रीएम्बल जो था लगभग उस तैयार कर दिया। प्रीएम्बल में कहा गया है सोवरेनिटी, जो सोशलिटी और सेकुलर रिपब्लिक और डेमोक्रेटिक और रिपब्लिक होगा, जहाँ पे जस्टिस इक्वालिटी जहाँ पे जस्टिस लिबर्टी इक्वालिटी और फ्रेटर्निटी की बात की, जहाँ पे जस्टिस 3 टाइप की होगी, सोशल, इकोनॉमिकल और पॉलिटिकल। लिबर्टी जो होगी वो थॉट की, एक्सप्रेशन की, बिलीफ की, फेथ की, वर्शिप की होगी और इक्वालिटी जो होगी इक्वालिटी ऑफ स्टेटस एंड अपॉर्चुनिटी, इक्वालिटी ऑफ स्टेटस एंड अपॉर्चुनिटी, सबको इक्वल स्टेटस दिया जाएगा, अपॉर्चुनिटी दिया जाएगा। एंड टू प्रमोट देम ऑफ फ्रेटर्निटी किसकी होगी, फ्रेटर्निटी जो होगी डिग्निटी ऑफ इंडिविजुअल, लोगों के लिए खुद की डिग्निटी ऑफ इंडिविजुअल होगा और एक डिग्निटी ऑफ इंडिविजुअल होगा और यूनिटी एंड इंटीग्रिटी ऑफ द नेशन का इंटीग्रिटी और यूनिटी और इंटीग्रिटी ऑफ नेशन रहना चाहिए। और क्या कहते हैं, डिग्निटी ऑफ इंडिविजुअल होनी चाहिए। इस तरीके से हमने 26 नवंबर 1946-49 को हमने अपने प्रेम्बल जो कि संविधान था उसको लिया। तो चैलेंजेस बाय द इंडिपेंडेंस एक्ट, और इस तरीके से चैलेंज बाय इंडिपेंडेंस एक्ट, अब क्या हुआ कि चैलेंजेस हमारे सामने आए और हमने उन्हें सॉल्व करा। धीमे धीमे बहुत 2 साल लगे, 2 साल 18 महीने 11 दिन लगभग लग गए। इस तरीके से 11 महीने 18 दिन लगे। अदर फंक्शन ऑफ द परफॉर्म, और बहुत सारे अलग अलग फंक्शन किए गए। उसके बाद कुछ कमेटियाँ बनी। कमेटियाँ जो थी उन्होंने अपना काम डिवाइड कर लिया। कमेटी ऑफ द कॉन्स्टिट्यूशनल असेंबली, जिस तरीके से पार्लियामेंट्री कमेटी होती है, जैसे आपने पार्लियामेंट्री कमेटी पढ़ा होगा, फाइनेंस में पढ़ा होगा, पब्लिक अकाउंट कमेटी होती है, एस्टिमेट कमेटी होती है, कंटीजेंसी पब्लिक अकाउंट कमेटी होती है, फाइनेंस कमेटी होती है, और पब्लिक अंडरस्टैंडिंग कमेटी होती है। उसी तरीके से डिपार्टमेंटल कमेटी होती है। उसके बाद इंक्वायरी कमेटी होती है। इंक्वायरी में पिटिशन प्रिविलेजेस और पिटिशन की बात करी जाती है। उसके बाद इंक्वायरी कमेटी होती है। उसके बाद डे टू डे होती है और लाइब्रेरी, ये सब कमेटी होती है। उसी तरीके से कमेटी ऑफ द कॉन्स्टिट्यूशनल असेंबली, कमेटी ऑफ द कॉन्स्टिट्यूशनल असेंबलीज बनाएगी, जहाँ पे मेजर कमेटी थी, माइनर कमेटी थी और ड्राफ्टिंग कमेटी। मेजर कमेटीज़ में जो थी, सबसे पहले मेजर कमेटी 6 थी। उसमें ड्राफ्टिंग कमेटी थी, फंडामेंटल कमेटी थी, नेहरू के हाथ में थी, सरदार पटेल के हाथ में थी, और इस तरीके से और भी कमेटी थी। ड्राफ्टिंग माइनर कमेटीज़ भी थी, जिसमें कृपलानी थे और छोटे छोटे थे। लेकिन ड्राफ्टिंग कमेटी जो थी सबसे बड़ी कमेटी थी। ड्राफ्टिंग कमेटी में 6 लोग थे और इसको हेड कर रहे थे, क्या कहते हैं, B.R. अम्बेडकर जी कर रहे थे। इसमें B.R. अम्बेडकर जी कर रहे थे। और सबसे पहले क्या हुआ, जो प्रेसिडेंट बनाया गया इसमें S. सिन्हा को बनाया गया था, क्योंकि वो सबसे बड़े बुजुर्ग थे। उसके बाद डॉक्टर राजेंद्र प्रसाद को बनाया गया, और उन्हीं की अध्यक्षता में हमने पूरा अपना कॉन्स्टिट्यूशन तैयार किया। और उसमें बताया कॉन्स्टिट्यूशन की कुछ इनएक्टमेंट ऑफ कॉन्स्टिट्यूशन, और फिर हमने अपने कॉन्स्टिट्यूशन को इनैक्ट करा। 26 नवंबर 1949 को हमने कॉन्स्टिट्यूशन बनाया, जिसमें 5 या उसमें से कुछ जो चीज़ें थी वो लागू हो गई थी, बाकी जो थी वो 26 जनवरी 1950 को हमारा पूरा जो कॉन्स्टिट्यूशन था लागू हुआ। उसी दिन से हम रिपब्लिक डे मनाना चालू करते हैं। तो इन्फोर्समेंट ऑफ द कॉन्स्टिट्यूशन, और फिर क्या हुआ कि हमने अपने कॉन्स्टिट्यूशन को इन्फोर्स कर दिया। इन्फोर्समेंट ऑफ द कॉन्स्टिट्यूशन, क्रिटिनिज्म, बहुत सारे क्रिटिनिज्म भी हुए कॉन्स्टिट्यूशन असेंबली के, कि भैया कॉन्स्टिट्यूशन असेंबली जो है वो कोई कहते हैं सभी को रिप्रेजेंट नहीं करती है, केवल हिंदू को रिप्रेजेंट करती है। वहाँ पे इंडियन नेशनल कांग्रेस के लोग हैं, लेकिन सरासर गलत था। उस कॉन्स्टिट्यूशन असेंबली में सिख भी थे, क्रिश्चियंस भी थे, पारसीज भी थे, और हिंदू मुस्लिम भी थे, एंग्लो इंडियन के भी थे, और इम्पॉर्टेंट फैक्ट। इस तरीके से हमारा ये जो कॉन्स्टिट्यूशन बना। उसके बाद हमने जो कॉन्स्टिट्यूशन बना, उसके बाद उस कॉन्स्टिट्यूशन के बाद हमने उस साइलेंट फीचर ऑफ द कॉन्स्टिट्यूशन, हमारे कॉन्स्टिट्यूशन की कौन कौन सी साइलेंट फीचर्स हैं उसमें बात चली। तो पहले इंट्रोडक्शन जो था कि जो हमारा साइलेंट फीचर्स में जो हमारा कॉन्स्टिट्यूशन है, वो उसमें प्रेम्बल जो है, प्रेम्बल में लिखा है वी द पीपल ऑफ इंडिया हैविंग sovereignly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizen, हम अपने सभी नागरिकों को जस्टिस देते हैं। जस्टिस इस टाइप की पॉलिटिकल, सोशल, इकोनॉमिकल, 3 टाइप की जस्टिस दी गई। लिबर्टी दी गई। लिबर्टी जो दी गई थी वो थॉट की दी गई, एक्सप्रेशन की दी गई, बिलीफ की दी गई, फेथ की दी गई, और वर्शिप, 5 टाइप की लिबर्टी दी गई। और उसके बाद इक्वालिटी दी गई, इक्वालिटी ऑफ स्टेटस एंड अपॉर्चुनिटी, सभी को इक्वल स्टेटस दिया जाएगा, अपॉर्चुनिटी दी जाएगी। एंड टू प्रमोट ऑल देम फ्रेटर्निटी, सभी को फ्रेटर्निटी, भाईचारे के साथ एज्यूमिंग द डिग्निटी ऑफ इंडिविजुअल, अकेले खुद के लिए डिग्निटी ऑफ इंडिविजुअल, और यूनिटी एंड इंटीग्रिटी ऑफ द नेशन। इस तरीके से अवर कॉन्स्टिट्यूशन असेंबली दिस 26 डे, ये 26 नवंबर 1949 को हमने हेयर बाय अडॉप्ट किया, इनैक्ट किया एंड गिव टू आवर सेल्फ, खुद को दिस कॉन्स्टिट्यूशन, और हम सभी अपने आप को ये कॉन्स्टिट्यूशन देते हैं। इसी के साथ साइलेंट फीचर्स जो हैं हमारे कॉन्स्टिट्यूशन की सबसे है, इसमें लेंदीएस्ट कॉन्स्टिट्यूशन है, क्योंकि इसमें लगभग 365 आर्टिकल्स हैं। उसके बाद इसमें अमेंडमेंट किए गए, पहला अमेंडमेंट तो 1951 में ही किया गया, जिसमें प्रॉपर्टी राइट आर्टिकल 13 और 368 को लेके विवाद था। लेंदीएस्ट रिटन कॉन्स्टिट्यूशन, ये लेंदीएस्ट रिटन कॉन्स्टिट्यूशन है। लेंदीएस्ट रिटन कॉन्स्टिट्यूशन इसलिए भी है क्योंकि इसमें शुरुआत में 7-8 शेड्यूल थे, उसके बाद उसमें 9, 10, 11, 12 4 शेड्यूल और जोड़ दिए गए। पहले जो पार्ट थे वो 22 थे और उसमें 25 कर दिए गए। पहले जो क्या कहते हैं आर्टिकल 295 थे, अब उसमें 465 से भी ज़्यादा आ चुके हैं। इस तरीके से जो हमारा प्रीएम्बल था उसमें 1442 में कॉन्स्टिट्यूशन अमेंडमेंट एक्ट करा गया और 3 चीज़ें जोड़ी गई, सोशलिस्ट, सेकुलर और इंटीग्रिटी, और बहुत सारे भी चेंजेस किए गए। तो ड्रॉन फ्रॉम वेरियस सोर्सेज, हमने जो कॉन्स्टिट्यूशन था उसे बहुत सारे सोर्सेज से लिया, लगभग दुनिया के सारे सोर्सेज पढ़े। इसमें सबसे ज़्यादा हमने जो लिया उसमें गवर्नमेंट ऑफ इंडिया एक्ट 1935 लिया, जिसमें इक्वालिटी ऑफ लॉ, इक्वालिटी बिफोर लॉ, रूल ऑफ लॉ एंड पार्लियामेंट्री सिस्टम, और यूएसए से जो लिया हमने फेडरल, और वहाँ से सुप्रीम कोर्ट, इस तरीके की 2 चीज़ों को लिया। उसके बाद हमने साउथ अफ्रीका से अमेंडमेंट लिया, ऑस्ट्रेलिया से कॉन्करेंट लिस्टें ली, और क्या कहते हैं कनाडा से फेडरल अपॉइंटमेंट, कैसे गवर्नर अपॉइंट किया जाता है, राज्यसभा में कैसे इलेक्शंस होते हैं। फ्रांस से भी हमने चीज़ें ली, एरिस से हमने क्या कहते हैं डीपीएसपी ली, फंडामेंटल राइट्स जो थे वो यूएसए से लिए, फंडामेंटल ड्यूटीज़ जो थी वो रशिया से ली, इमरजेंसी जैसे डिक्लेयर करनी है जर्मनी से ली। और इस तरीके से हमने बहुत सारे चीज़ों से ड्रॉ करके, ड्रॉन फ्रॉम द वेरियस सोर्सेज, अलग अलग सोर्सेज से ड्रॉ करा, इस तरीके से हमने कॉन्स्टिट्यूशन बनाया। ब्लेंड ऑफ द रिजिडिटी एंड द फ्लेक्सिबिलिटी, ब्लेंडिंग ऑफ द रिजिडिटी एंड फ्लेक्सिबिलिटी, जो ब्रिटेन का कॉन्स्टिट्यूशन है वो बहुत ही फ्लेक्सिबल है। वहाँ पे पार्लियामेंट सुप्रीम है, पार्लियामेंट जो चाहे वो सब कुछ चेंज कर सकती है, वुमेन को मैन और मैन को सब कुछ चेंज कर सकती है, और वहाँ पे फ्लेक्सिबिलिटी बहुत ज़्यादा है क्योंकि उनका रिटन कॉन्स्टिट्यूशन नहीं है। लेकिन अमेरिका जो कॉन्स्टिट्यूशन है वो बहुत ही ज़्यादा रिजिड है, उसको चेंज करने के लिए हमें वहाँ की 50 स्टेट में अमेंडमेंट करना होता है, और फिर इस तरीके से वहाँ पे अमेंडमेंट हो पाना बहुत मुश्किल है। फेडरल सिस्टम एंड विद यूनिटरी बेसिस, और इस तरीके से हमने अमेरिका से फेडरल सिस्टम लिया, लेकिन फेडरल वर्ड हमारे इंडियन कॉन्स्टिट्यूशन में कहीं भी इस्तेमाल नहीं किया गया है। फेडरल कॉन्स्टिट्यूशन संघवाद के ढांचे पे बताया गया है। जैसे अमेरिका में 15 स्टेट थी, उन्होंने मिलकर एक नया नेशन बनाया और सभी को इक्वल राइट दिए गए, और सभी को लगभग इक्वल सीनेट, वहाँ की सीनेट जो है, जैसे इंडिया में राज्यसभा होती है वहाँ पे सीनेट है, और वहाँ पे रिप्रेजेंटेटिव हाउस जैसे लोकसभा होती है उनको लगभग 2-2 वोट सभी को देनी, सभी 2-2 सीट्स अलाउड करी गई। लेकिन जो फेडरेशन सिस्टम है अमेरिका का और इंडिया का वो बिल्कुल अलग है, क्योंकि अमेरिका का जो फेडरेशन सिस्टम है वहाँ पे वो इंडेस्टिबल है, लेकिन हमारा जो फेडरेशन है वो इंडेस्टिबल नहीं है, क्योंकि हमें फेडरल यूज़ नहीं करके यूनियन ऑफ इंडिया कहा है। यूनियन ऑफ इंडिया मीन्स हमारा जो फेडरेशन सिस्टम हो किसी समझौते पे नहीं है, बल्कि सभी के द्वारा मिलकर बनाया गया है, और एक सिंपल एक्ट इमरजेंसी के द्वारा प्रेसिडेंट इमरजेंसी डिक्लेयर कर देता है तो यूनिटरी बेसिस बन जाता है। हमारा जो फेडरलिज्म है वो कनाडा टोटली जो है वो अमेरिका पे बेस्ड नहीं है बल्कि यूनिटरी बेसिस पे भी है। और इस तरीके से पार्लियामेंट्री फॉर्म ऑफ गवर्नमेंट, हमने जो पार्लियामेंट्री फॉर्म ऑफ गवर्नमेंट बनाई जहाँ पे पार्लियामेंट में पार्लियामेंट्री फॉर्म ऑफ गवर्नमेंट हमने गवर्नमेंट ऑफ इंडिया 1935 ब्रिटेन से लिया। और पार्लियामेंट फॉर्म ऑफ गवर्नमेंट में तीन लोग होते हैं, जिसमें होती है लोकसभा, राज्यसभा और प्रेसिडेंट। लोकसभा जो होती है जिसे लोअर हाउस कहते हैं, राज्यसभा जो होती है अपर हाउस कहते हैं। लोअर हाउस को अमेरिका में पीपल्स रिप्रेजेंटेटिव कहा जाता है और लॉर्ड ऑफ कॉमन्स कहा जाता है यूएसए में, ब्रिटेन में। लेकिन जो राज्यसभा है उसको इंडिया में अपर हाउस कहा जाता है और ब्रिटेन में उसको कहते हैं लॉर्ड हाउस कहा जाता है और वहाँ पे उसको सीनेट किया जाता है। इस तरीके से यहाँ पे लोकसभा और राज्यसभा, जो लोकसभा होती है वो डायरेक्टली इलेक्ट होकर आती है पूरी जनता से। जो राज्यसभा होती है वो स्टेट की जो इलेक्टेड मेंबर्स होते हैं उनके द्वारा सिंगल ट्रांसफर वोट के बेसिस पे चुन के आते हैं। इस तरह हमारे इंडिया में पार्लियामेंट्री फॉर्म ऑफ गवर्नमेंट है और स्टेट में भी हमने पार्लियामेंट्री फॉर्म ऑफ गवर्नमेंट बनाई है। लेकिन 6 स्टेटों में वहाँ पे लेजिस्लेटिव असेंबली और लेजिस्लेटिव काउंसिल भी है, बाकी में नहीं है। लेजिस्लेटिव काउंसिल जो है वो महाराष्ट्र में है, कर्नाटका में है, आंध्र प्रदेश में है, तेलंगाना में है और क्या कहते हैं यूपी और बिहार में है। अभी लेजिस्लेटिव काउंसिल तमिलनाडु के पास थी लेकिन उसने छोड़ दी, अब वो फिर से गेन करना चाहता है। तो अगर आपको लेजिस्लेटिव काउंसिल चाहिए उसके लिए आप क्या कर सकते हैं कि राज्यसभा में उसके लिए बिल ला कर उसमें आप लेजिस्लेटिव काउंसिल बना सकते हैं। इस तरीके से सिंथेसिस ऑफ पार्लियामेंट्री सोवरेनिटी एंड जुडिशियल सुप्रीमेसी, हमने ब्रिटेन से पार्लियामेंट्री फॉर्म ऑफ गवर्नमेंट ली जहाँ पे वहाँ पे सोवरेनिटी जो थी ब्रिटेन में वहाँ पे ब्रिटेन ही सबसे ज़्यादा सुप्रीम है, सब सोवरेनिटी है। पार्लियामेंट कोई भी डिसीजन ले सकती है और वहाँ पे कोई उस पार्लियामेंट से ऊपर कोई नहीं है। लेकिन इसीलिए हमने सोवरेनिटी जो सोवरेनिटी है वो पार्लियामेंट्री फॉर्म ऑफ सोवरेनिटी जो ब्रिटेन से ली। लेकिन हम जो अमेरिका था वहाँ पे जुडिशियल है वो सुप्रीम है, जुडिशियल रिव्यू कर सकती है किसी भी लॉ को, वो खारिज कर सकती है अगर वो बेसिक स्ट्रक्चर के खिलाफ होगा या फिर फंडामेंटल को रोकेगा। इस तरीके से अमेरिका का जो जुडिशरी सिस्टम है बहुत स्ट्रॉन्ग है। लेकिन इस पूरे दुनिया में जो हमने जो अपना सिस्टम बनाया वो ना अमेरिका से जुडिशरी सिस्टम को सुप्रीम रखा और ना ही पार्लियामेंट को सुप्रीम रखा। हमारे यहाँ जो सुप्रीम है वो कॉन्स्टिट्यूशन है, कॉन्स्टिट्यूशन के ऊपर कोई नहीं है, कॉन्स्टिट्यूशन से नीचे ही सभी लोग हैं और कॉन्स्टिट्यूशन में ही सब लोग हैं, कॉन्स्टिट्यूशन से बढ़कर कोई नहीं है। इसलिए लेजिस्लेचर जो है वो लॉ बना सकती है लेकिन कॉन्स्टिट्यूशन के अंदर रहकर, और सुप्रीमेसी जो है अपना जुडिशियल रिव्यू कर सकती है अगर वो कॉन्स्टिट्यूशन के गारंटर के फॉर्म में, फंडामेंटल राइट्स के गार्जियन के फॉर्म में देखी जाती है। इस तरीके से हमने जो जुडिशियल सिस्टम है वो अमेरिका के जुडिशियल सिस्टम से लिया। उसके बाद हमने देखा कि हमारा जो जुडिशियल सिस्टम है वो इंटीग्रेटेड और इंडिपेंडेंट जुडिशरी है। हमने हमारे कंट्री में लॉ मेकिंग बॉडी जो कानून बनाती है जिसे कार्यपालिका कहते हैं, न्यायपालिका जो होती है न्याय करती है, और जो लॉ कानून बनाने वाली है लेजिस्लेचर, एग्जीक्यूटिव और जुडिशरी। जो जुडिशरी है वो हमारे कॉन्स्टिट्यूशन को कहते गार्जियन बताया गया, फंडामेंटल राइट्स को गारंटी देती है, और जो लॉ है वो लेजिस्लेचर बनाता है। लॉ में जो एग्जीक्यूटिव है वो रन करती है, जो एग्जीक्यूटिव है वो रिस्पॉन्सिबल होती है, वो लेजिस्लेचर के ही मेंबर्स होते हैं। फंडामेंटल राइट्स, हमने अपने सभी इंडियंस को फंडामेंटल राइट्स दिए। फंडामेंटल राइट्स में हमने राइट टू इक्वालिटी, फंडामेंटल राइट्स में राइट टू इक्वालिटी दी, राइट टू फ्रीडम दिया, राइट टू एक्सप्लॉयटेशन, राइट टू फ्रीडम ऑफ रिलीजन, राइट टू कल्चरल एंड एजुकेशनल राइट्स दिए, राइट टू प्रॉपर्टी जो कि लीगल राइट बना दिए गए 300A में रखकर। इस तरीके से हमने बताया कि जो फंडामेंटल राइट्स हैं ये जस्टिसेबल हैं, इनको सुप्रीम कोर्ट में आप चैलेंज कर सकते हैं। इसमें जो आर्टिकल 32 है वो उसे हार्ट एंड सोल कहा जाता है, पूरे कॉन्स्टिट्यूशन में उसे हार्ट एंड सोल कहा जाता है, क्योंकि आर्टिकल 32 जो है वो रिट्स जारी करता है, जैसे हार्बिस कॉर्पस जारी करता है, हार्बिस कॉर्पस जो होता है मैंडेमस जारी करता है, वी कमांड किसी ऑफिसर के खिलाफ, उसके बाद प्रोहिबिशनरी चालू करता है फॉरबिड करने के लिए किसी, और सेंचुरी और लास्ट में क्यू वारंटो जारी करता है। इस तरीके से जो फंडामेंटल राइट्स हैं वो पंडित नेहरू ने 1929 में कराची लाहौर में कहा था कि फंडामेंटल राइट्स होने चाहिए, हम सभी भारतीयों को फंडामेंटल राइट्स देंगे। लेकिन डीपीएसपी हैं, डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी, ये इरिश से लिए गए हैं। इरिश ने स्पेन से लिया था, स्पेनिश ऑरिजिन मानी जाती है। जो डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी होती हैं ये बहुत इंपॉर्टेंट होती हैं, क्योंकि ये जो फंडामेंटल राइट्स होते हैं वो नागरिकों के अधिकार होते हैं, नागरिकों को दिया गया है। जो फंडामेंटल राइट्स हैं वो नागरिकों को दिए गए हैं, और जो डीपीएसपी हैं वो हमारे गवर्नमेंट को दिए गए हैं। जो डीपीएसपी हैं, जिन्हें डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी कहते हैं, वो नोवल आइडिया है, इंस्ट्रूमेंट ऑफ इंस्ट्रक्शन है, जो स्टेट को इंस्ट्रक्ट करते हैं इंस्ट्रूमेंट की तरीके से। नेक्स्ट है सेकुलर स्टेट। सेकुलर स्टेट मीन्स द state have not a religion, it is totally based on the fundamental qualities, and universal adult franchises got the right to all citizens to give the right of vote. And next, single citizenship means in USA dual citizenship is given because of 50 states existing in them. Next is individual bodies. Indian Constitution में individual bodies हैं, like Election Commission of India, Union Public Service Commission, and Finance Commission, Article 280. An emergency provision also granted to the Article 352 and 356 and 349. Article 365 got the if the constitution not run accordingly. Next is three-tier government. Three-tier government, basically the 73rd amendment of 73rd and 74th amendment of PVC in 1993, that is 24 April Panchayati Raj system. And this three-tier government basically work on the Article 14, that is formation of village panchayat. Then cooperative society, according to Article 87 Constitution Amendment Act, the cooperative society 43B article promote the cooperative society to form the cooperative society and cooperate and form the cooperation with them. And there are many criticism according to the constitution that make many criticism that it is a bulge or over constitution. It is a very huge constitution. It is a paradise of the lawyers, and there is a more complexity. Criticism are given from many persons that borrowed the constitution. It is basically the constitution which borrowed all over the world, and like is America, USA, Australia, Japan, France, South Africa, and Germany. And carbon copy of the Act of 1935 Act, and the carbon copy of the 1935 Act, the un-Indian and un-citizen, basically the anti-Indian and un-Indian, because the constitution framed by the basically the lawyers which are un-Indian and anti-citizen. Un-Gandhian constitution, because the basic theme of the constitution is based on the Gandhiji, and because the Jinnah and Gandhiji is not present in the assembly, and the Gandhi's concept is basically included in the CSP, that direct principle of state policy. But this is also the elephantized size of constitution and the paradise of the lawyers, because most of the people sitting in the constitution assembly, they have the paradise of the lawyers, hence it is scrutinized many more times. Now we have come to the point that preamble, basically the preamble is the Preamble of the Constitution. The text of the preamble will start with the "We people of India having sovereignly resolved to constitute India into a sovereign, socialistic, secular republic, democratic republic, and to secure all of citizens justice, which is three types: social, political, and economical, and the liberty of thought expression, belief, faith, and worship, and the equality of status and opportunity, and the fraternity of the fraternity of the dignity of the individual, and unity and integrity of the nation. Next, the integrant of the integrant of the preamble. These four of sovereignty, socialist, secular, democratic republic, justice, equality, liberty, equality, and fraternity are the almost five to six, five, four, nine integrant words which are included in my constitution. First is the sovereignty. It means that we are very sovereign and not ruled by anyone, just whether it is a member of we or no. Also, we are totally sovereign and make the constitution in the parliament, just like parliament of the USA. Next is socialist. Socialist means we work for the society, and this socialist and the secular word are included in the 42nd amendment constitution, and integrity also included. Democratic means we are very democratic, and because the government is by the people, from the people, and for the people. And republic means there is a head which is not a heredity, but basically they should elected, and the justice for all, whether it is economical, political, and social, and justice for all. And there is a PSP, that is 39A, which give equal justice for and free legal aid. That is, we establish the NAP Panchayat family courts, NALSA, National Legal Authority. Next is liberty. Liberty is basically liberty, equality, and fraternity. We take from the French, because this is the basic principle from the French Revolution. And next is the justice, liberty, equality, and fraternity. Significance of the preamble. Basically, Golagnath case, which is basically said that it is the part of preamble, because preamble is not the part of constitution. But in the Keshavanand Bharati case, said that preamble is also a part of the constitution. Next is preamble is a part of constitution, and it can be amended. But the Keshavanand Bharati case says that whatever you can change all the parts of the Indian constitution, but you cannot change the basic principle of the constitution, because it is the soul and heart of the constitution. Amendability. The article 368 said that we can convert or amend the constitution in three ways: simple majority, special majority, and special majority with ratified 2/3 and with the one half of the states. Next is the union, that is its territory. Union is territory. Basically, the union is territory 29 states and 7 UTs, because JK is dissolved in the union territories, and Daman and Diu and Nagar Haveli are included in the one, and that is 28 into 8 union territories. Now, union of state means that there is a union of state which is not a result of, just like America, Federation of the America, where they are destructible, where in India is indestructible of a state, indestructible of union, but destructible in a state. Hence, India is basically, that is Bharat, and all the princely state which submerge 552 princely state, Junagadh and Hyderabad and JK also. And the parliament, next point, parliamentary form to reorganize the state. Parliamentary power to reorganize the state means Parliament have the power to reorganize the state, to change the boundary, to create the new state, to submerge the new state, and these rights can give the sovereignty. Sikkim, that is the Sikkim, which is added in the Schedule 10, but after it got the status of the state, and it is removed from the Schedule 10. Next, evolution of the state and the union territories. How the evolution of states and the union territories during the 1947 to 2020. That is, first is integrated of the princely state. First of all, integration of the princely state. After we got Indian 1947, a whole of the constitution is divided into, whole of the Indian territories are divided into four group A, B, C, D, where A is totally the provinces which ruled by the Britishers, and the B is the totally the princely state, and C, that is mostly the territories, and this D is the Andaman Nicobar. Now we disband C and D and all the princely state, and the state come into the A group A and B. Now there is a commission known as Dhar Commission and JPB Commission. SK Dhar Commission basically formed to reorganize the state on the basis of linguistic, but it neglected and said that India should be reorganized on the basis of administrative, not on the linguistic or the region, really secular basis. And after that, JPB committee is formed and it give the that the reorganization of the Indian state must be on the basis of administration, not on the religious basis. Then at last the Fazl Ali Commission, which is totally Fazl Ali Commission totally recognized that we must divide the Indian state in the on a linguistic basis, but there is a harmony, not one language, one linguistic, one state, but is to harmonize. There is must to harmonize the Indian state and the religion, which is basically the cooperative one. Next, the new state and the union territories created after 1956. From them, and the new states are union state and union territories are created after 1956. First is Maharashtra and Gujarat. After the Bombay is created, and in 1960 we formed the Gujarat and Maharashtra as a two state. After 1961 we get Dadar and Nagar Haveli from the Portugal, and the Mandu and Goa from in 1962, and Dadar and Nagar Haveli 1961 from the Union Territories, and Goa and Daman and Diu in 1962. Next is the Pondicherry, which is the formation of Pondicherry, Mahe, which is Mahe situated in Kerala, Pondicherry and Karaikal is situated in the Tamil Nadu, and Yanam, which is situated in the Andhra Pradesh. And these four submerged, amalgamated and formed in the Pondicherry in 1962, which is basically which have the legislature, also legislative assembly, and take the part in the election of the president and the prime minister. Pondicherry 1962. Then there is a Nagaland in 1960 with the Nagalism, National Naga Front Accord was signed with them, formation of 1963 as a new state. Then the Punjab is bifurcated into three more other states, that is Haryana, Chandigarh and Himachal Pradesh in 1962, and formation of Haryana, Chandigarh and Himachal Pradesh in 1963, because Haryana is totally Hindi speaking people, and the Punjab is basically Punjabi, and Himachal Pradesh, which is totally a lower range of the Shivaliks, it is and Chandigarh, which is tri-junction of these three have the capital. Shimla is the capital of Himachal Pradesh, and the Chandigarh is the common or joint secretariat of the Haryana and Punjab in 1962. Then Manipuri, Tripura and Meghalaya in 1972. In 1972, the Manipur, Tripura and Meghalaya formed the secular state. Next, 1975, Sikkim, which is basically the union territory, make into the state. Mizoram, Arunachal Pradesh and Goa again in 1987 formed the independent state. Then 2000 Chhattisgarh from the MP, and Uttarakhand from the Uttar Pradesh, and Jharkhand from the Bihar, bifurcated and form a individual state. The last and the new state, which is Telangana 2004, and the latest, the state of JK is bifurcated into Jammu and Kashmir and the Ladakh one. In this way, we have formed from 14 state to 28 state now. Next is citizenship. Basically, when we come to any country, there is much citizenship, because citizenship have the legal right to utilize the political and social powers. The meaning and the significance: how the citizen utilize the fundamental right, because fundamental rights are given to the citizen, and they have the right to have have the protection under the judiciary system. Then the constitutional provision give the right to the citizen, and how the constitution provision give the citizen, that is OIC, overseas citizen of India, PIO, PIO, overseas, and PIO, and Citizenship Amendment Act, that is CA. It is 1953, and it got more amendment according to, and the latest is 2019. The acquisition of citizenship: how anybody can give, how anybody got the citizenship. First is the by birth. Any person who is born on India by birth is an Indian citizen, and by birth it is blood based, and by birth which is soil based, and by descent by the blood based. And the registration is also blood based, and naturalization. The person who is living in India at least more than 7 years, then it is neutral, give the citizens with naturalization basis. And the incorporating of the citizenship, by incorporating of the incorporative of the territory. If any state or any territory incorporated into them, then it is basically come under them. A special provision of the citizenship of the person covered by the Assam Accord and Assam Accord NRC, non-registered citizens, Assam Accord, Nagaland Accord, which is basically submerged in them. Then loss of the citizen: how the people get lost the citizenship: if by renomination, if they already give renunciation, and by termination and the deprivation. So renunciation, termination, and the deprivation. Single citizenship: India got a single citizenship, not just like America, because single citizenship is taken from the British. Overseas citizen of India, overseas OCI and PIO are submerged in 2014, because Modi said that all these PIO and OCI are submerged. Registration: how the OCI citizenship got. Registration of the overseas citizen of India cash card holder. Conferment of the rights and the overseas citizen of India, and the renunciation of the overseas citizen of British card, and cancellation of the registration and the overseas citizenship to the cash holder. Next, as most important part, this is the fundamental right and feature of the fundamental right. Features of the fundamental right means a feature which is given to the citizen, not to the city. Fundamental right, few are also given to the aliens also. Fundamental right, that is equality before law, and discrimination basis on the ground, and the public employment, that is 14, 15, 16, which is basically given to the Indian only, and for all, that is 20 and 21 given to all of them. Definition of what do you mean by state, that is article 12 to article 35, article 12 to article 35, which form fundamental rights. And definition of the state, that is the parliament, legislature, local authorities, private and public issue, private and public institution also got a definition of state. Law inconsistent with fundamental right: any law which is formed after the 1947, 1947 and before 1947, it inconsistent, null and void, and if it hinder the any fundamental right. Right to equality means right to equality, which is the fundamental right. Article 14, equality before law means all people are equal before the law. No one inferior, no one the superior in the eye of the law. This means jurist, AC jure said that rule of law, the law which is rule of law means the rule rule of law is equal for all, and the equal protection of law which is the American origin, means equal protection of law, means there is a protection, equal protection for the equity, to make them equal protection of law. There is a equality before law and equal protection of law. Equality before law is Britain origin, because all of equal in the eye of law, and equality before equal protection of law are in the eye of given protection also, just like reservation and another subsidy. Prohibition of the discrimination on the certain ground. No one can be prohibited on the ground of five fact: religion, race, caste, sex, and birth of birth, place. So religion, race, caste, and sex, and the place. Five factors cannot be discriminated on the ground, but in special cases God given. Equality of opportunity in the public employment equality, not on certain ground, but the president and the governors and the MPs and MLAs have given the special provision for them. They are not equal before law. Discrimination is also based on this ground. Reservation, like equality of opportunity in the public employment. Mandal Commission, Moraji Desai and Mandal Commission is formed to give the opportunity for 27% reservation for the OBs, which is criminal layer and non-criminal layer. Non-criminal layer gov reservation and criminal layer is discarded from this point view. The same is also applicable to the scheduled caste and scheduled tribe, but is not allowed them. Abolition of the untouchability. Article 17 said that abolition of untouchability is a offensible if any person, it is offensible, and also the abolition of untouchability and for abolition of the title from the Article 19. Next one, the right to freedom. Right to freedom means Article 19 protection of six right means freedom of speech and expression. It must be freedom has speech and expression. Freedom of assembly, they have the right to assemble. Freedom of association and cooperative is the 87th amendment which make the cooperative also. So freedom of the speech and expression, freedom of the assembly, freedom of the association, freedom of the movement, freedom of residence, freedom of profession, freedom of speech and expression, freedom of assembly, freedom of association, freedom of movement, freedom of residence, and freedom of profession. Then protection in the respect of conventional offenses. Article 20 means protection in the respect of conviction or conviction for offense. Conviction for the offense. If we got any offense, then there is a conviction to protect them from the point of view. Protection of the life and personal liberty. And the protection of life and personal liberty. Next is right to education. Right to education is make the fundamental in Article 21. And next 22, protection against the arrest and detention. If anyone is in arrest or detention, it should be protected. Next article, right against exploitation. Prohibition of the trafficking in human being, prohibition of the trafficking from the human being and forced labor, and prohibition of the employment of the children in the child labor amendment factors. Next, right to freedom of religion, which is 25 to 28, and first is 25, that is freedom of the consciences and the free profession, practice, and propagation of the religion. Freedom for consciences and free profession and practice and propagation of the religion. Then freedom to manage the religious affairs. All the religious affair can be managed by the people. And the freedom from the taxation for the promotion of the religion, have the right to give the promotion of the religion. And government is, because it is a secular, it provide the government adds, then there is a no secularity in the basis. But if they are trusted and funded by basically the trustees, then it give the religion basis. Freedom from the attending religious instruction in a freedom from attending religious instruction. Next is cultural and educational right. Cultural and educational rights are the Article 20, 29 and 30. Article 29 said that protection of the interest of minorities interest must be protected, and interest of the minorities must be protected in the 29. Protection of which type of language, script and culture? The minorities culture, language, culture, script and culture protected. Next is right to minorities to establish and administrate educational institution. And last and sixth is the right to constitutional remedies, because Article 32 is the whole and soul of the Indian Constitution. Writs, type and the scope. There is a writs which is Article 32, which is Ambedkar said that it is the heart and soul of the Indian Constitution, and the habeas corpus which give the right to give habeas corpus to represent the district magistrate within 24 hours excluding the time of interval, and the members means which command officer to do the legal duty. Prohibition means higher court to the lower court to the higher court to give out of it of this, and centrality also give the lower court to higher court. And then quo warranto means to justify the quo warranto, armed force and the fundamental rights, because all the fundamental rights of the armed forces are taken away because they are basically for the citizens of India, and if they violate the fundamental rights, then how it is? Then martial law and the fundamental rights affecting certain fundamental right affecting certain fundamental rights and present position of the right to property. Next, exemptions of the fundamental, how the few exemptions are taking to place for the fundamental rights. Saving of the law providing for acquisition of the state, because at 1947 the acquisition and the land consolidation, land ceiling and land reforms basically not uniform or actively taken place. That is why the first two revolutions are failed, and the constitution makers, there is a loopholes formed like just Golaknath case and Keshwanand Bharti case 1973 give the basic structure of the Indian Constitution. Then exemption of the fundamental rights, that is saving of the laws and the providing for the acquisition of the state. Next is validity of certain act and regulation. There is validation of the certain act and the regulation. Saving of laws giving effective to the certain directive principle, means saving of laws. First, saving of laws providing for acquisition of state, then saving of laws. There are some laws which are saving because the acquisition of state take place, and validation of certain act and the regulation. Then fundamental right, DPSP and fundamental right, always a conflict between them, and the saving of laws giving effect to the certain directive principle. Then criteria for the fundamental rights. Fundamental rights criticism also be taken for the fundamental right, just excessive limitation, because more and more limitation are taking to citizens. That is why it's called excessive limitation. And no social and common right, there is a no social and common right. No clarity, there is a no clarity. No permanency and suspension, and almost all the articles are suspended during the emergency, that is 352, 356 and 358 and 365 also. That is only two articles are expanded, that article 20 and 21, because 21 is the article related to the life and the personal liberty. Next is significance of the fundamental right. What is the significance of the fundamental and outline of the part third. Next is the DPSP basically these are the novel features of these right given to the state to make the state in a welfare state. That is why after 5 years the people must accountable to the government. That is directive principle of state policy is the basic novel feature in instruction for instruction for instruction for the instrument to the state. First feature of the directive principle, it is also a similar to less like fundamental right, but is not justable. Classification of the directive principle, there is a no justable classification of the fundamental. Basically the all the fundamental rights are divided into three categories, that is socialist, Gandhian and liberal. Socialist feature, because socialist is not just the USSR, because socialist is welfare society, to make the welfare. Gandhian principle of in the Gandhian view, and the liberal, which is intellectual and scientific basis. New directive principles is added, that is a new directive principle added to the, that is participation of worker in the management of industries, article 43A, and in the article 43B, promotion of the cooperative industries, and article 39A, that is equal justice and free legal aid given to all, and article 48, protection of the improvement of the environment and safeguarding of the forest and the wildlife, and the article 51, that is fundamental rights. These are the three DPSP which are added latest one. Then the section behind the directive principle, criticism of the directive principle. There is more directive principle which have criticism, that is no legal force. There is no legal force, illogical, because all most of them are illogical, constructive, and the constitution conflict, because if fundamental rights are given to the citizen, then there is violation of the DPSP. And utility of the DPSP, because DPSP is basically the main feature of the Planning Commission, National NDC, National Developing Council. Conflict between the DPSP and fundamental right, there is more cases in them. Implementation of the directive principle. Implementation of the directive principle basically deal to the welfare state, and directive outline of the outside the part 4. They are in the part 4. Basically the DPSP 38 state that state to be secure of social order for the promotion of welfare of the people. Article 39, certain principle of policy to be followed by the state, and 39A, equal justice and free legal aid. And article 40, organization of village panchayat. And article 41, right to work, to educate, and to public assistance in the certain cases. Provision for the just and human condition for work and maternity belief. And article 43, living wages for the workers. Article 43, participation of worker in the management of industries. And article 43, promotion of cooperative societies. Article 44, uniform civil code for the citizens. And 46, article 45, provision for the early childhood care, that is education to children before the age of 6 years. And 46, promotion of the education and economic. For 46, promotion of educational and economic interest of SC/ST and other weaker section. And article 47, to raise the level of the nutrition and the standard of living to promote public health. And article 48, organization of the agriculture and the animal husbandry. Article 48A, protection of the improvement of the environment and the safeguarding of the forest and wildlife. Article 49, protection of the monument and the place of the objects of the natural importance. Article 50, separation of the judiciary from the executive. And article 51, promotion of international peace and security. In this way, article 51, which are fundamental rights are given by the Swarn Singh committee, and it is checked by Verma committee. Swarn Singh committee recommendation to give the 8 fundamental right, which voting of right and taxation of fundamental right, but is not listed in them. A list of the fundamental right, and there are totally 11 fundamental right. Basically, they are 10, and last 11 fundamental right, that is education to the child to 6 to 14 years. There is a responsibility for the parents to educate his child in 4 to 16 years. First fundamental right means respect ideas institution like flag and anthem. Noble ideas inspired the national struggle for freedom. And third, protect sovereignty, unity and integrity, and defend and render national service and ready for national service, and promote harmony and the spirit. Fifth and sixth, preserve the rich heritage and one fundamental right, that is 49, that is promotion of the monuments and the place and object of national importance. Articles fundamental 7, that is the protection, improve the national environment. 8, safeguarding scientific temperament and harmony and sprout inspiracy and reform. Article safeguard public prosperity and excellence small. And this way the feature of the fundamental rights. Criticness of the fundamental right, there is also criticness for the fundamental rights and significance of the fundamental right, and Verma committee overruled this fundamental right. Next is amendment of the constitution. Amendment, which is article 368, procedure for the amendment. There is amendment 368, constitutional amendment bill, and the simple amendment bill. The constitution amendment bill be taken by 3 ways: by simple majority of the parliament, and a special majority of the parliament, and a special majority of parliament and consent of the state. Then simple majority, special majority for fundamental right and DPSP and other which are not into the first and third, and special majority of that is 7th schedule, president election, and schedule Supreme Court orders, and criticism of the amendment procedure. Next, basic structure, because after the Keshwanand Bharti case, that Golaknath case, Minwa Mill case, and Champane is and many more cases which basically give the Supreme Court, you can amend all the part of the, but you cannot change the basic structure of the Indian Constitution. Emergence of the Indian basic structure and elements of the basic structure, and all the basic almost feature of the preamble, which is part of the basic structure. Next is the system of government. There are three. There is the system of government, that is parliamentary system, and there is a federal system. Parliamentary system, which is really basically USA, UK, and federal system, which is UK. And there is a center-state relation, because we are federal. That is, there is also state center-state relationship, and there is an inter-state relations. Then last is the emergency provision. First is the parliamentary form of government. Parliamentary form of government, which is UK, that is feature of the parliamentary government, nominal and real executive, because parliamentary form have nominal and real executive, but we have nominal and real executive, because the real executive is PM and nominal is the president. And we not a hereditary like just UK, we have elected on single transfer like prime president. Majority party rule, and in the house where the party which is got majority, it is ruled by them, and which collectively responsible to the Lok Sabha, and individually responsible to the President of India on the behalf of PM. And collective responsibility, political homogeneity. Political homogeneity means the executive and the legislative because they represent the same political party, there is though no harassment or the clashes between them. Double membership, because they are the part of legislature and they are also the part of the executive. Leadership of the prime minister, because it is said that it is the captain of the ship. The dissolution of the lower house, after 5 years, or if it lost the majority, the dissolution by the president take place. Secrecy take place. Then feature of the presidential government. Presidential form of government is also merits and demerits. First is parliamentary form of government. Harmony merits harmony between the legislature and executive, because both executive are the part of legislature. Responsible government, because this executive is represented all the responsible government, which is majority party rule. Prevent depositism. Depositism means prevent depositism to make them free and federal. Ready alternative government. If one not prove the floor test, then alternative government form. While representation, and it is the representative of the people of India. There is also demerits. First is the unstable government, and during the 1990s, that for 1969 1966 to 1999, 4 or 5 PM are declared but unstable form of government form. No continuity of the policies after each Lok Sabha is dissolved, and the principle also and the policy also discontinued. No discontinuity of the policies. And dictatorship of the cabinet, because cabinet, which is the part of council of minister, cabinet ministers, cabinet state minister, and independent state ministers. And against separation of power, there is separation of power, government by amateurs. Reason for adopting the parliamentary form of government. So reason for the aging, because familiarity with the system. We are very familiar with the system of the parliamentary form of government, and the preference to more responsibility. Need to avoid the legislative executive conflict and nature of the Indian society. Distinction between the Indian and the British model, because we take the from British, but is very different from the British model. Federal system taken from the USA, and it is very different from the USA. Federal feature of the constitution. What is double polity? Because double polity, that is it's central government and state government. And written constitution. USA has also the written constitution, and we have also written constitution, but in America the state and center both have written constitution, but Indian there is a one constitution. Division of the power. Article schedule 7 empower them the state list, concurrent list, and the union list. In union list 100 subjects included, and in concurrent list is 1197, and in state list it is that is 65. And supremacy of the constitution. Supremacy of constitution, because federal form of government, supremacy is supremacy of the constitution. In India the constitution is very supreme. And rigid constitution. In a federal form of government, there is a very rigidity to amend the constitution. Independent judiciary. There is also independent judiciary and bicameralism. There is in the state two form of government, that is legislative council and legislative assembly. Then is unitary feature of the Indian constitution, that is strong center. After the emergency declared president rule, the strong center is formed, and all the federal system is dissolved with only one act. Nation not and state not indestructible. State not indestructible, but in USA the state is indestructible. But India is not indestructible, but having the state which is indestructible. Single citizenship like US, like single citizenship like in like UK. Flexibility of the constitution. The flexibility given to the constitution, because it is unitary system. Flexibility is given to. No equality of the state representation. And emergency provision for to harsh habitat. Single citizenship given to the Indian citizen, and integrated judiciary system. All India services, and the integrated audit machinery, which focus check and balance to the Indian Parliament. Parliamentary authority over the state list and appointment of the governor on the pleasure of the president. And the integrated election machine, that is Election Commission of India, Article 324, and vote over the state bills. And vote over the state bills means the governor take the bills in their hand for the recognition of the president. Then the critical evolution of the federal system. there is a 17 years have passed. 70 years have passed to given the running of the 70 years of Indian Constitution, and there is a drawback and also the supremacy is given to them. Next is center state relation, legislature relation. First is relation. Legislation relation means where the center form the law, as center form the law in the respect of state. State also form the law according to the state list, and center form the in the union list. But center form the concurrent list, then the state law is null and void. The territorial extent of the center and the state. Then second is distribution of the legislative subjects. Distribution of legislative subjects are distributed. Parliamentary legislature in the state field, parliament legislation in the state field. The state matters can also be found by the parliament legislation in the certain points, that is when Rajya Sabha and 2 or 3 government emergency या फिर president rule. The center's control over the state legislation. Next is administration. Administration is how the center-state relation during the administrative relations. The distribution of the executive power. The executive power means the distribution of executive power and obligation of the state and center. When the center given the instruction or the obligation, and the center's direction to the state when the emergency or president rule is given. Mutual delegation of function, mutual delegation of the function, and coordination between the center and the state. How the center and state can coordinate all India services, which is Pandit and Patel said it is the steel framework for India, because in the federal system all India services are IAS, IFS and IRS. Public commission, the state have also the public submission commission and also a joint public commission, and the integrated judicial system, which means the High Court, Supreme Court and subordinate court. And in subordinate court there is a district and session court. District means district judicial court, and the municipal court. There is also judicial session court and the court. Initial integrated judicial system and relation during the emergency or other provision. Extra constitutional devices also given. Financial relation. The legislative administration, legislature power, legislature relation, administrative relation. Then is financial relation. Financial means allocating of the taxing powers, and how the taxing power, distribution of the tax revenue, how the tax revenue is distributed according to the Finance Commission. 42%, 32 to 42%, but today it is 41%. 1% is utilized in the Jammu and Kashmir. That is distribution of the non-tax revenue, and the grant in add to the state and state grant and discretionary grant. Finance Commission, according to Article 280, the Finance Commission protection of the state's interest in borrowing by the center and the state. Intergovernmental tax immunity, and the effect of the emergency and trend in the central relation. Next is tension areas in the central relation. Next is administrative reform. Reforms. First, ARC report give the relation between central and Rajmanar Committee, West Bengal, and Anand Sahib resolution of the Punjab and West Bengal memorandum. But Sarkaria Commission, Panchi Commission are basically the most reliable, and Panchi Commission, which is 2002, and second ARC report 2005, give how the government power is very pleasure to the president. Next is inter-state relationship. Inter-state relation means inter-relation state water dispute, because most of the states are having the dispute water, like Kaveri water issues, Krishna Ravi dispute, and the water dispute tribunals are formed for the water dispute, because these are binding to the state, and no dispute this case is taken in the Supreme Court. And the interstate council basically council to welfare of the interstate council, and PM is the head, then CM. And this establishment of the interstate council to administered by PM, and then CM, then the CM of the Pondicherry and Delhi, then the administrator of the union territories, that is Lieutenant Governor, and the administrators. Then the interstate trade and commerce, and how the interstate trade and commerce take place. Last and final, that is zonal council. India is divided into 4 zones: north, south, east, west, and the northeastern zone. And the 4 zones basically Delhi, Mumbai, Kolkata, and Guwahati. All the 5 zones are in the hand of Home Minister, and all CMs and all the administrator of the Delhi and the Pondicherry and the UT's administrator, and also the state. Next, last is the emergency provision. Emergency provision is the provision which protect us from the risk or the external emergence. The national emergency first time declared 1962, second time 1965, third time 1971, and 1975 to 1979. That is the internal emergency. According to internal emergency, Article 353, Article 50, 352, 355, 370, 360. Then national emergency. During the national emergency, all the fundamental are dissolved, null and void, except Article 20 and 21. Ground of declaration. What are the ground national emergency declared? Parliamentary approval and duration. How the emergency declared? It must be approved from the parliament, and after 6 months it must be re-approved, and up to infinity. Revocation of the proclamation, and how the emergency will revocable. Effect of the national emergency. During the national emergency, effect of the central state relation, and how the central state relation come under the uniform form of the unitary form of government. Effect on the life of the Lok Sabha and the Rajya Sabha. And during the national emergency, the effect which has taken place on the state assembly and Lok Sabha, and the effect of the fundamental rights. Distinction between the Article 358 and 359. 358 and 359 and the declaration made so far. The president rule to national emergency. Then second is the president rule या फिर president rule, that is ground of imposition. On what ground president is imposition the imposition of the governor give the report of the proper state is running according to the constitution, and if it is not running according to constitution, then president on their report of the state governor and itself impose the president rule. Ground of the imposition, that is a parliamentary approval, and the duration and the consequences of the president rule. Article 356 basically the state when it is not functioning according to the constitutional will. Scope of the judicial review. So judicial review also take place, but it is responsible for them. Cases for the proper and improper uses. Financial emergency. Financial emergency is mostly not declared yet, but in 1990 there are conditions which creating the ground on the declaration. Then parliamentary approval of the duration and the effect of the financial emergency. Criticism of the emergency of the provisions for the parliamentary emergency. Next is the second part, which is the president election of president. This is electoral college. Electoral college means MLA. MLA is the unit, MLA total population and number of seat, number of elected uh, number divided by 1000. The unit must be divided to the number of seat in the parliament. Then the qualification: oath qualification 35 years, and oath preserve, protect and preserve, protect and preserve, protect, preserve, protect of the Indian Constitution. Qualification of the election of the president, and oath and affirmation by the president. Then the condition of president rule: in what condition president office can be ruled. Term impeachment, vacancy impeachment: if 50 from the Lok Sabha and 20 member from the Rajya Sabha, then the impeachment is started in any house. Term of the president office, that is 5 year. Impeachment of the president take place in the Lok Sabha, either the Rajya Sabha with 50 signatory or 20 signatory in the Rajya Sabha. Vacancy in the president office: if the vacant, the vice president act, and if vice president is vacant, then senior most judge of the high court take the president height. It never be vacant whether any condition. Power of the function of the president: all the work on the behalf of president, that is called executive power. Executive power is basically happen in the behalf of, whether it is appointment of PM, appointment of council of minister, appointment of UPSC head, election commission head, Supreme Court judges, administrators, finance commission, delimitation commission, or it is a law commission. Almost all the state scheduled caste, scheduled tribes administration, it is in the hand of executive. Next is in law making. Legislative power give the assent to the bill, then submission, session of the parliament, that is dissolution or prorogation, and election of the to appoint the pro tem speaker, if speaker, deputy speaker, then appointment of the persons, and in this way the legislative council. The financial contingency fund of India, and the consolidated fund of India, and financial power give the assent to the money bill and passing the budget, financial bills and appropriation bills. Judicial power, that is give the judicial power pardoning the death sentence, also reprieve, respite, remission. And next is diplomatic. All the international diplomacy take place. Military power: supreme commander of the Indian Armed Forces, and the emergency power: on the emergency power 352, 352, 352, 365, 356, 352, 356, president, and the 360, 360 given. Then vice veto power of the president. There are 4 veto power, that is veto power: absolute veto power, substantive and pocket. Absolute veto power: absolute means it is money bill can be reject or accept, but not remit. But ordinary bill simply reject, remit, or any cases return to them. Then suspensive veto is not for the Indian, it is all the USA. Pocket veto means the bill is in the pocket and there is no time limit for them. Presidential veto over the state legislature. A state legislature, if pass the bill to the governor, and governor take the bill for the consideration of the president, then this bill is this veto power over the state legislation. Ordinance making power of the president. Ordinance making power of the president, that is 123, and state government 213. So 123 or 213. Power of the president have the power when the Lok Sabha is not in session, means the ordinance passed 123, and it is must be, if when the Lok Sabha come in the session, then within the 6 month and 6 week after the starting of Lok Sabha, it can be passed by the parliament. This is the pardoning power of the president, that is pardon, commutation, remission, respite and respite. Pardon, toting the death sentences. Commutation means to change the nature of the punishment. Remission means remission, to give the temporary out of service, and respite to give the maternity leave, and deprive to change the time period. Respite. Constitutional position of the president. Constitution is the constitutional provision of the president. President is the head of the our constitution. Next is the vice president. Vice president election same as the president, and president is also removed, give to the president, and president given to the vice president, and vice president qualification also same, because it is a part of the president, and is also the ex officio chairman of the Rajya Sabha. Then oath and affirmation takes same. Conflict of condition of the office. Term of the office 5 years, 5 years, and it is also ex officio chairman of Rajya Sabha. Vacancy of the offices and election dispute. If the election dispute, then election of prime minister and president in taking the Supreme Court. Then power and the function same. Power and function is the ex officio chairman of the Rajya Sabha, and the salary is given to the not vice president but on the ex officio chairman. And the India and American vice president compared. Indian president is not the part remaining. New fresh election within 6 months, so that new president can be compared. In America, the president which on the point can be continue, the next election cannot be held. Emolument, there is emolument PM. The appointment of PM, appointment of PM according to the Article 74. According to Article 74, there is a Council of Ministers to give aid and advice to the President, and Article 75 to appoint the PM of the majority party. And oath, appointment of the PM. Oath, term and safe salary. Oath, term and salary. Oath to take the constitution to sovereignty, integrity and unity, and the term and salary. Power and the function of Prime Minister in relation with the Council of Ministers. Council of Ministers is responsible for the collectively for the Lok Sabha and individually for the President. In relation to Article 74 and 75, 78, in relation to the President, PM is a communication channel between the Council of Ministers and the President, because all the functions are taking place in the name and fame of the President. In relation to the President, in relation to the Parliament, in relation to the Parliament, President in Lok Sabha, PM is the leader of the majority party and leader of opposition also. Oath, powers and function, and other powers, because he is the ex officio chairman of the Niti Aayog, and also the interstate council, and major ministries in the hands. And role description. Relationship with the President. PM also communicate between the Council of Ministers and the President. Chief Ministers who became the PM basically the C.V. Gowda and Morarji Desai from Bombay, and P.V. Narasimha Rao, that is Karnataka, and Narendra Modi, and V.P. Singh and Charan Singh. Next is Council of Ministers. Council of Ministers means there is a Council of Ministers which constitutional provision is the Council of Ministers 74. Article 74 give that Council of Ministers to give. Article 74 Council of Ministers in aid and advise the President. Article 75 other provision of the ministers, that is PM can be nominated from PM with the help of PM. Council of Ministers take place. 78 is duty of the Prime Minister to communicate between the PM and the Council of State. Article 88 right of the minister as a respect in the House. Nature of the nature of advice of the minister, and nature of advisors of the minister. Appointment of the minister, and PM President appoint the minister, that is cabinet minister, state minister, individual independent state minister. Oath and salary of the minister. Responsibility of the minister collectively, because all the minister collectively responsible, and individual and no legal hand. Composition of the Council of Ministers. Composition of Council of Ministers. Composition of Council of Municipal and the Council of Ministers versus the Cabinet. A role of Cabinet. Council of Ministers and Cabinet. Role of Cabinet. Next is the Cabinet Committee. Because the Cabinet Minister are only 15% of the total seat of the Lok Sabha, and 15% there is a small cabinet, that is cabinet, and these cabinet, that is Finance Minister, Home Minister, Defense Minister, and the Farmer Agriculture Minister. And the feature of the Cabinet Ministry is to take the immediate decision. There is a special committee formed. There are total for 2013 almost 10 committee, but today there are only 6 to 5. That is political committee on the political affair, political, economical appointment, and political, economical appointment, and small other committees. The list of the cabinet 1994, 2013, 2016. Minimum government, maximum governance. Minimum government, maximum government. The view of the Preamble. Function of the cabinet ministry is to give the cabinet committees are appointed by them. Group of minister and each. Abolition of the group of minister and empowered group of minister can be banned, and informal GM formed. There is kitchen cabinet because kitchen cabinet is a personal cabinet of the, which is not a cabinet, which is not cabinet is the minister cabinet, but kitchen cabinet is the PM's small cabinet which give add and advice to them. Next is parliament without composition, organization of the Parliament. Organization of the Parliament, because Parliament is made up of Lok Sabha, Rajya Sabha, and the President. Lok Sabha 245 seat, 2 are for the Anglo-Indian, and other 543 are for the 543 for the 250 total seat, 2 seat for the Anglo-Indian, and 20 seat for the UDs, and 30 for the Lok Sabha. But present 245, 2 are for the Anglo, which has abolished, that is 2 and 20 seat, that is 20 seat, 245, 21, 225 seat are for the Lok Sabha to the Lok Sabha, and 250 seat for the Rajya Sabha. 12 are nominated from the literature, art, science, and social sciences. Composition of the House, composition of the Rajya Sabha in the same manner, based on nomination, and system of the election in the Lok Sabha, and duration of the houses, membership of the Parliament, qualification and disqualification, oath and affirmation, and the salaries, and the presiding officer of the President. Parliament presiding officer means the Speaker, and the Speaker, how the election of the Speaker, tenure, role, power, and function. Joint sitting, that is 108, and money section, and the presiding, the classes, voting, these are taking the part of Speaker. And independence and impartiality. Deputy Speaker of the Lok Sabha and the panel of chairman of the Lok Sabha. This panel of person of when the President, when the Speaker and Deputy Speaker is not present, means not vacant, means not present, then these chairmen are taking place. Speaker of pro tem Speaker, when first Lok Sabha is come, then the pro tem Speaker, which is take the sitting and take the oath also of them, and the new Speaker came. That pro tem Speaker have the same power also. The chairman of the Rajya Sabha, there is the vice president, deputy chairman of the Rajya Sabha, and chairman of the Rajya Sabha have not the right to vote. Deputy chairman of the Rajya Sabha have right to vote. Panel of vice chairman in the Rajya Sabha and Secretariat of Parliament, both for Lok Sabha and Rajya Sabha, and the leader of the Parliament. Leader of the Lok Sabha, that is CM, and leader of opposition. In the same Rajya Sabha, there is a leader of opposition and leader of the majority. Next is session of the Parliament. Session of the summoning means sessions of the session of the parliament. There are 3 sessions: budget session, monsoon session, winter session. First budget session is mostly 4 months, and the monsoon session 3 months, and the winter session for 2 months. Summing means summing of the for the session. Adjournment means for not time liquid. It adjourn for the definite time, that is for a few hours, for minute, for week. Or adjournment sine die means infinity, in adjourn to infinity. Prorogation to terminate the session. To terminate the session is not prorogation. And to dissolve after the 5 years, and if majority is not in the hand of PM, then dissolution. And when the dissolution take place, most of the Lok Sabha bills which are pending in the Lok Sabha are also lapses, but when they are passed from the Lok Sabha and also passed from the Rajya Sabha, and for the assent or the joint sitting passed from the assent and passed by the Rajya Sabha but not Lok Sabha, then it does not lapse. Then there is a dissolution and prorogation of the session means that is terminating the whole session, not dissolve the 5. Dissolution means all the Lok Sabha dissolved. Quorum means the attendance, that is 1/10 member of the parliament must, then only proceeding of the Lok Sabha take place. Voting on the house take place, and when it is not win-win situation, then the speaker and the deputy speaker take the part. Language of the starting language is English and Hindi, but 1965 Hindi for next not yet is cannot be removed. Right of ministers and the Attorney General. Right of Minister and Attorney General is the one according to Article 76. There is AG which have the right but not vote. They have the right to sit in the either house of the parliament. Lame duck session. Lame duck session means lame duck session, which is the last session, which is the last session, and the person which are not coming when they got last this session. Next, devices of the parliamentary proceeding. First is 0 hour. 0 hour is the 11 to 12, 12 to 1 hour for the question hour. 0 hour question hour, that is 3 type of question. That is unsteered question and short notice question. So steered question are orally, and there is a supplementary question also. But unsteered question are written, and no supplementary question. Short notice question is written. It give 10 day in the written form. Next is 0 hour. It is the innovation of India only. And motion, there is 3 type of motion, that is substantive motion, substitutive motion, and short. And third is point of order. Point of order means when the court is not doing the proceeding according to their rule book, then is it point of order. Half hour discussion take place special matters in week 3 days, and short duration motion other 2 weeks. Special motion is a non-conference motion or censure motion is called special motion. Resolution passed for the special purpose. Young parliament is basically the parliament which give the awareness and the concern is still about the working of the parliament. Next is the legislature procedure in the parliament. Ordinary bills, money bills, parliamentary financial bill 1 and financial bill 2. Ordinary bill, it is the first. All the bills have the same proceeding. First reading, second reading, third reading, bill in the second house, and assent to the president. First reading, second reading, third reading, same will be happen in the second house, and assent of the president. First reading, normally reading the matter, sub matter. Second reading, detailed discussion, that is given to the parliament committees scrutining the then third reading, and third reading is then second to the bill. Money bill, it is decided totally by the it is speaker and already assent taken from the president, and it is binding for the president whether it is reject or accept, but it cannot return the bill to the Lok Sabha or Rajya Sabha. Parliament financial bill, all the money bills, all the financial bill are money bill, but all money bill are not financial bill. Financial bill and financial bill 2. There is a joint sitting in the Article 108 that joint sitting of the two houses, but the joint sitting is not for the budget in the parliament. When budget in the parliament and budget in the parliament, basically in 2098 first time budget will be submerged. In 1921 it is totally separated, and 2017 it is submerged, and the first time it is taking on 1st February, that is 11, and 2000 it is taken 5 to it is on morning 8 a.m. 11 a.m. Then constitutional provision. According to the constitutional provision, budget is the income and expenditure, in revenue and the expenditure estimation, that is physical policy is made by the help of budget. There is a charge expenditure and voting on expenditure. Charge expenditure basically the salary which are for the Supreme Court judges, Election Commission, Union Public Service Commission, CBC, Controller General, all have which are independent bodies have totally charged from the Constitution Fund of Constitution Fund. There is a contingency fund and the public account fund also. And stages in the enactment. Presentation of budget. First presentation, there are 6 steps taken for the enactment of the first presentation of budget. General discussion, scrutinizing the scrutiny of the department committee, that is 24 committee, voting on the demand of the grant, and passing of the appropriation bills and the passing of the financial bill. Appropriation without appropriation bill, the parliament, the consolidated fund money cannot be taken from the then passing of the financial bills, then the whole step is completed and signed by the president. Other grant, that is supplementary grant, additional grant, excess grant, vote of credit, and the exception token grant. There is a voting on the demand for the grant, that is token, policy cut, economic cut, token cut. Policy cut, token cut, and economic cut. Then fund is 3 type. Consolidated Fund of India, without voting no money is taken from the consolidated. Contingency fund is for disaster emergency, but the money will taken again from the consolidated fund, which is voting. It means public account is in the hand, is a contingency fund in the hand of secretary of finance, and public account with the remittances and any all the part of this. Multifunctional role of the parliament. Many roles of the parliament: executive, for judiciary, financial, election, and many more. Indifference of the parliamentary control, because Rajya Sabha have all India rank, legislative law for the state have them. Parliamentary privileges also given to the sovereignty of the parliament, because in Britain the parliament is supreme, and all the matters which is supremacy can be taken place in parliament. But our Indian constitution is parliamentary form, but the constitution is supreme. All the, whether it is judiciary, whether it is law, executive, all work according to the constitution, and judiciary take the check and balance and guardian of the Indian constitution and the fundamental rights. Written nature of the constitution: fundamental federal system of the government, system of the judicial review, and the fundamental rights. Next is the parliamentary committee. Basically the parliamentary committee classification of parliamentary. There is 2 type of committee, that is standing committee, ad hoc committee. Basically the advisory and inquiry committee. Parliamentary committee and standing committee. Financial committee, that is public account committee, estimate committee, and committee on the public understanding. There are 24 departmental standing committee, and the committee on the inquiry, that is privileges, petition, and ethic. ethic committee, that is moral values for them, and committee on the scrutinize and the control, how the committee scrutinize and control, that is government accuracy, paper land on the table, empowerment of the women, subordinate legislation, welfare of the state, and joint committee on the office of profit. Next, committee for the relating to the day-to-day business of the house, that is business advisory committee, rule committee, and committee on the absence of the member, committee on the private member bill and the resolutions. Then consultative committee means housekeeping committee, means general purpose committee, housekeeping committee, and library, joint committee on the salary and allowance of the members. Next is parliamentary forums. There is parliamentary forums, estimation of parliamentary forum, because it is just not parliamentary committee, it is the member, there is president, and there is forum where all the members come, and objective of the forum, composition of the forum. There is first forum is, that is water conservation and management, that is 2005, adlocks youth population, that is global warming and disaster management, artisan and the craftsmen, and the millennium goals. Next is parliamentary groups. Parliamentary group IGP, IPU, and CPA. Inter-Parliamentary Union and Commonwealth Parliamentary Affairs. The rationale of the group and the composition of the group and objective of the group. Thank you.